So, can a machine actually be an author? It's a question that's moving out of science fiction and straight into our courtrooms. I mean, as AI creates art, music, and text that looks completely human made, we're facing this fundamental challenge to how we even think about creativity and ownership.
In this explainer, we're going to dive into what we're calling the AI author. It's really a tale of two very different legal answers to this one very modern problem. We're going to explore how two of the world's major legal systems are trying to tackle this creative puzzle. Okay, let's get right into it. The central problem is this. Copyright, it has always been tied to a human creator. But when an AI generates an image or a piece of text, that link to a single human author it gets really blurry. So who gets the rights? Is it the user who wrote the prompt, the company that built the AI, or maybe no one? Right, let's start over in the United Kingdom, which has a surprisingly old yet pretty forward-thinking answer. It's all built on something called a legal fiction. Basically, an assumption the law makes to solve a practical problem, even if it isn't literally true.
Think about this. As far back as 1988, UK law actually defined a computer-generated work. The core idea here is nothing short of revolutionary for its time. It acknowledges that a work can be created without a traditional human author. And that single premise, that's the foundation for the UK's entire approach today.
And here is the ingenious, or depending on who you ask, controversial solution the law provides. If there's no human author, the law just creates one. Authorship is given to the person who made the arrangements necessary for the work's creation. So it's not about who held the pen, but about who built the machine that holds the pen. And this has some really clear consequences. The arranger becomes the legal author. Simple as that. But the copyright term is shorter. It's 50 years from the date of creation, not 70 years after the author's death. And crucially, there are no moral rights. That means the creator can't demand to be named or object if someone alters the work. It's a very pragmatic, business-first kind of solution. So the big question is, what does making arrangements actually mean? The term feels a little bit vague, doesn't it? Well, thankfully, a court case over a video game gave us a much clearer picture. In this case, Nova Production, the court decided the author was a Mr. Jones. And why? Because he did these three things. He didn't just operate the computer, he designed the visual assets, he set up the rules and the logic for how the game would actually assemble those assets, and then he wrote the code to make it all happen. He was, for all intents and purposes, the architect of the entire creative system. This case just perfectly illustrates the UK's philosophy. The court was absolutely clear. The player, the person who only interacted with the game, was not an author. Authorship belongs to the person who designed the entire system, the one who created the deterministic instrument that produces the art. Okay, now let's hop across the Atlantic to the United States, which takes a fundamentally different path. You see, the US system isn't looking for an arranger, it's searching for the creative fingerprint of a human author. And here is the core philosophical divide. The UK created a special category for works that have no human author. The US, on the other hand, refuses to accept that such a thing can even have a copyright. In the US, an AI must be a tool that assists a human. It can never, ever replace them. This ruling from the US Copyright Office is absolutely central to the whole debate over there. Just writing a prompt isn't enough to claim authorship. And the reason? Well, the office believes that current AIs fill in the gaps with their own sort of unpredictable creativity, and that breaks the chain of direct human control. So the standard in the US is what they call assistive use. The AI can be a very, very sophisticated paintbrush, but a human has to be the one wielding it. The tool can enhance your expression, sure, but it can't be a substitute for it. That creative spark, that personal touch, it has to come from a person. And this is the practical takeaway. If you want to copyright an AI-generated image in the US, prompting it just isn't going to cut it. You have to take the output and then significantly modify it, arrange it, or combine it with your own creative work. Your human touch has to be absolutely undeniable. The case of the comic book Zarya of the Dawn is the perfect example of this in action. The Copyright Office flatly refused to grant protection to the individual images that were generated by Midjourney. But, and this is the important part, it did grant copyright to the comic book as a whole. It recognized the human author's creativity in the selection, the sequencing, and the arrangement of those images, plus all the text she wrote herself. So, what we have are two very different approaches, one focused on arranging the system, the other on modifying the output. So, where does this leave us?
You know, this quote from a 1985 UK case feels surprisingly modern. It establishes a principle that really underpins both legal systems. A computer is just a tool, like a pen. The creativity comes from the human who's directing it. The huge disagreement today is about what directing the tool actually means in the age of AI.
And this is the actual work from that 1985 case. Looking at it, you can see why the court didn't see a machine's creation. It saw the direct output of a programmer's instructions. The computer was just a deterministic tool for executing a human's creative vision.
Let's just boil it all down to this final comparison. The UK model gives you authorship by arrangement. It rewards the person who designs the creative engine. The US model, however, gives you authorship by modification. It rewards the person who takes the raw output from that engine and then shapes it into a final, expressive piece of work.
And really, this goes way beyond the law. This whole debate is about what we, as a society, value in creativity. Is it the genius of the initial concept, the person who builds the system, or is it the hands-on craft of the final execution, the person who refines and perfects the output? Ultimately, as AI evolves from being a simple tool into a true creative partner, our laws are going to have to choose. Should copyright protect the person with the vision, who specifies the entire procedure, or should it protect the person with the skill, who perfects the final execution? The answer to that question is going to define the future of both human and machine creativity.